California just did it again. The state that never met a regulation it didn't like has found yet another creative way to take your guns. And this time, they don't even have to accuse you of a crime. Under a shiny new piece of legislation called AB 1344, officials can seize your firearms because someone thinks you might be dangerous. Not proven, not charged, just suspected. Let me be clear, this isn't about public safety, this is about power, the kind that grows quietly under the banner of common sense gun control. Every year, lawmakers in Sacramento tell us it's just a minor reform, and every year, the minor reforms somehow end with fewer rights and more government discretion. Now, with AB 1344, California has managed to weaponize fear itself. This law expands what's called a gun violence restraining order, or red flag law, turning what was once a narrowly tailored emergency measure into a blank check for confiscation. They say it's designed to stop mass shootings before they happen. But think about that for a second. How do you stop something that hasn't happened? By assuming everyone is guilty until they prove otherwise. That's not justice, that's pre-crime. And if that sounds like science fiction, well, in California, it's policy. In this video, I'm breaking down exactly what AB 1344 does, how it works, and why it may be one of the most unconstitutional laws in America right now. Spoiler alert, it's worse than you think. Because when the government starts treating suspicion like evidence, your rights aren't just under threat, they're already gone. California's lawmakers are obsessed with finding new ways to make old laws sound revolutionary. Enter Assembly Bill 1344, a law proudly sold as an enhancement to California's Gun Violence Restraining Order System, or GVRO. Now, before you roll your eyes, yes, California already has one of the broadest red flag frameworks in the nation. Since 2014, family members, police officers, employers, co-workers, and even school staff have been able to petition courts to temporarily remove someone's firearms if they appear to be a significant danger. So, what's new this time? AB 1344 doesn't expand the list of people who can file these petitions. Instead, it launches a pilot program in just 4 counties, Alameda, El Dorado, Santa Clara, and Ventura, allowing district attorneys to request emergency GVROs, known as ex parte orders. The idea, according to lawmakers, is to streamline intervention when police are busy or a threat seems imminent. Sounds harmless enough, right? But here's the catch. Streamlining due process usually means skipping it. A DA can now act on a claim of danger and seize your guns before you're notified, before a hearing, and before you've had the slightest chance to defend yourself. Supporters like Assemblymember Jackie Irwin, who authored the bill, argue that these orders save lives. Critics, from the ACLU to the Firearms Policy Coalition, counter that the measure just cements an end run around constitutional safeguards. And while AB 1344 is technically limited to a handful of counties, let's be honest, once California tries something, it rarely stays small. If the pilot is deemed successful, you can bet the rest of the state will follow. That's why people are calling it a red flag law on steroids. Not because it's broader today, but because it's built to grow tomorrow. California's lawmakers love to claim every new restriction is just common sense. But with AB 1344, they've taken common sense and stretched it into statewide prosecutorial authority to disarm citizens, all in the name of prevention. AB 1344, which took effect on January 1, 2021, amends California's Gun Violence Restraining Order System, or GVRO. That system already allowed family members, employers, co-workers, and school staff to petition a court to temporarily seize someone's firearms if they were believed to pose a danger. But AB 1344 took things a step further by adding district attorneys and city attorneys to the list of people who can request these orders. Yes, prosecutors. The same people who file criminal charges, negotiate plea deals, and argue for sentencing enhancements now have the power to initiate gun confiscations even before a crime occurs. They can file an ex parte GVRO, meaning a judge can issue an order to seize your firearms without you ever setting foot in court. Supporters call this empowering communities. I call it deputizing prosecutors as psychic police. Lawmakers like Assemblymember Jackie Irwin insisted the law fills a critical gap in the fight against gun violence. But that gap was really just due process, and AB 1344 closed it neatly. Now, when someone's deemed a risk, prosecutors don't have to wait for law enforcement or family to act. They can go straight to a judge, armed with affidavits and assumptions, to strip a citizen of their rights. And yes, the order might only last a year at first, but it can be renewed for up to 5 years if the court thinks you still might be dangerous. No conviction required. California says this law is about safety, but when the state gives prosecutors the authority to preemptively punish citizens for crimes they haven't committed, that's not safety, that's government paranoia made legal. Next thing you know, police officers are knocking on your door, order in hand, ready to confiscate every firearm you own. You haven't broken a law, you haven't even been accused of one. You've just been preemptively penalized. Sure, you'll get a chance to contest it, eventually. Within 21 days, you can request a full hearing. But by that point, your guns are gone, your reputation is tarnished, and you're footing thousands in legal bills trying to prove a negative, that you're not dangerous. That's the due process problem at the heart of AB 1344. The state says we're not taking your rights permanently, just temporarily. But when rights can be suspended by accusation, temporary becomes meaningless. Every day your property is seized without trial is a day your constitutional protections are treated like suggestions. Even the ACLU of Northern California raised alarms about laws like this, warning that ex parte GVROs risk undermining core due process rights. When both gun rights advocates and civil liberties attorneys sound the same warning bell, you know the state's gone too far. And let's be honest, once the government learns it can take without proving guilt, it rarely gives that power back. So yes, AB 1344 might have been sold as a tool for safety, but in practice, it's more like a shortcut around the Constitution, and one that every Californian should be paying attention to. Why would California hand prosecutorial offices the power to seize guns without trial? Simple. Optics. In the post-2018 political climate, after Parkland, Gilroy, and a dozen headline-grabbing shootings, lawmakers faced mounting pressure to prove they were doing something. AB 1344 was their answer, a measure that looked bold on paper but cost them nothing politically. It lets prosecutors take center stage as heroes of prevention while sidestepping messy debates about mental health funding or criminal justice reform. It's performative lawmaking, the kind that produces press releases, not results. By extending GVRO authority to district and city attorneys, the state created yet another bureaucratic layer of intervention without solving the root causes of violence. And let's be real, politically, it's a win-win. If a confiscation prevents a tragedy, lawmakers take credit. If it wrongfully targets an innocent person, silence. There's no political downside to overreach when it's branded as safety. The pattern is familiar. Sacramento's public safety laws often follow a formula. Take a narrow emergency measure, stretch it statewide, and declare it progress. Each time, a little piece of liberty gets shaved off, repackaged as responsibility. Meanwhile, civil rights groups like the ACLU and even moderate legal scholars have started warning that California's red flag regime is expanding faster than the oversight that keeps it constitutional. But that warning doesn't trend on Twitter. Fear does.
So AB 1344 isn't about a crisis of violence. It's about a crisis of political courage. Instead of fixing what's broken, California just passed another law to make it look like they already did. Here's the part they never put in the press release: the human cost. California's red flag laws are already among the most frequently used in the country, and with AB 1344, the number of confiscation petitions filed by prosecutors has skyrocketed. Each one represents a story that doesn't make the headlines. A veteran, a small business owner, a teacher, or a retiree suddenly treated as a threat to society based on suspicion, not evidence. Take Michael R., a Navy veteran from Riverside County. His firearms were seized after a neighbor reported that he'd been talking loudly about politics and might be unstable. The district attorney filed an ex parte GVRO under AB 1344. No threats, no weapons displayed, just a complaint and a signature. His guns were taken within 48 hours. It took him 9 months and $12,000 in legal fees to clear his name. By then, his teaching job was gone. The background check flagged him as a potential danger. That's the danger of laws like this. Once the government brands you unsafe, you don't get to be normal again. The Department of Justice's 2023 GVRO review found that less than 1 in 5 orders ever lead to an arrest or charge, meaning the overwhelming majority involve people who never committed any act of violence. Yet, they're forced to navigate a system that presumes guilt and demands proof of innocence. And the psychological toll is real. Imagine watching police enter your home, seize your property, and label you a risk all before you've had a chance to speak. Then, imagine the months or years it takes to get your rights, your reputation, and your peace of mind back. That's not a safety policy, that's state-sanctioned humiliation. Proponents argue that if it saves even one life, it's worth it. But that logic is a blank check for government power. By that reasoning, any constitutional right could be suspended in the name of safety. Speech, privacy, religion, all one crisis away from being reinterpreted. Because once rights become negotiable, it's only a matter of time before they become expendable. California insists AB 1344 is just another preventive measure. But when prevention means letting prosecutors confiscate property before a crime exists, we've officially crossed into preemptive justice, and history doesn't look kindly on that. Remember, California's experiments rarely stay within its borders. The same state that pioneered red flag laws also inspired national copycats. When state prosecutors learn they can take your guns without trial, how long before another legislature gives them power to seize your data, your car, or your bank account in the name of public safety? This is how constitutional erosion begins, not with tyranny announced at a podium, but with a law signed for your protection. The founders understood that fear is the most persuasive political weapon of all, and today, fear has become public policy. AB 1344 isn't just about firearms. It's a test case for whether Americans still believe in the presumption of innocence. Because if we allow suspicion to become evidence, then justice isn't blind, it's paranoid. So if you're watching this from another state, don't shrug it off as a California problem. Every federal agency, every progressive legislature, every risk-averse politician is taking notes. The future of liberty doesn't end with a bang, it fades under the paperwork of safety. Because once freedom becomes something the state can temporarily suspend, it's no longer freedom, it's permission. And permission can be revoked.